This is Jailani Hussein, Executive Director for the Council of American Islamic Relations. I want to bring to you this opportunity today to explain some information about the Chauvin trial that all of us and the entire world is looking towards, which was planning to start on Monday. With me today to explain and hopefully give us some answers is Simon, who is a local attorney who specifically is very famous in the Somali community, but is an attorney at Troutman and Martin Law, and also is a Richfield City Council member for the past 5 years, civil rights attorney, and among other things. We wanted to kind of cover some basics. I know there's just so much information that has come up about the trial. So, Simon, thank you for having some time with us and being able to provide some basic information for us.
It's good to see you, Jelani, and thank you so much for the invitation.
Absolutely. And so let's start us off, the trial.
Yes.
Can you explain, and I know there's, we are all at different levels of understanding what is expected in the media. We just see headlines. So
yes.
Can you explain the big picture? What is this timeline? How do we go from this Monday all the way down to a verdict? What is that big picture look like?
So there are a couple of words that you might hear if you listen to the news. They'll say wadir and motions in limine, and that 99% of the people will not necessarily recognize what that means. What that means is we don't have the trial like when you see a trial on television where there's a judge and there's a jury. The first step is there are motions, and a motion is just a fancy way to say I'm going to ask the court to do something.
Right.
And there are times where you ask the court to do something in the middle of the trial, and there are times where you ask the court to do things before the trial. And so now if you watch today, there were a lot of motions in limine, but that was asking the court to say, would you do this, would you not do this? What are the rules for the court going to be?
And it's standard for motion to even dismiss the case, which in this case happened earlier, and right?
Yeah, so that could be a motion. In this case, I thought it was really interesting. The defendant, Derek Chauvin, his attorney asked that the court would use his name and not refer to him as the defendant, which I think is really interesting because I think as a policy, that is probably a good policy, because when you just refer to somebody as the defendant, it dehumanizes them. So however we get to that place in our court system, this is a painful time, of course, for the world. But I hope that some of the fruit of this pain is not just healing and justice, but growth. And I think one way that one motion in limine that we could grow from is, as a matter of policy, we should refer to people by their names in court. And so that was something that the attorneys asked for, and the judge said that's going to be the rule. We're going to humanize people.
Can you then tell us what is expected now? What are those big moments leading up to the eventual, hopefully, verdict?
Well, and eventually there will be a verdict, and we don't know exactly. So what we found out today, at the end of last week, there was an appeal, and maybe we should start by saying what an appeal is.
Right.
So at the trial court level, where Judge Cahill is now presiding, if one of the attorneys or one of the parties thinks the judge has made a mistake, they can appeal that mistake to the Court of Appeals, and there is a layer after that, which is the Supreme Court. And so right now, the state and our Attorney General Keith Ellison has asked the court to add an additional charge, murder in the third degree, which is an unintentional killing where somebody had a depraved mind and was callously indifferent to human life. And so the Court of Appeals directed the trial court to reinsert that, or they said something slightly different. They said you can't exclude murder in the third degree. And so now that decision came from the appellate court to the trial court, and the defense said, well, we're not happy with that. So the defense has the right to go to the Supreme Court and ask that the Supreme Court change the ruling that the Court of Appeals made. And that's a challenging, we call that a heavy lift. That's a heavy lift for the defense because the Supreme Court does not often hear appeals.
But that would require additional time.
That would require additional time. So right now, the courts are taking the time, or right now they have the time to file the appeal, and we'll wait to see if the Supreme Court will hear that case or not. If the Supreme Court hears that case, they may hear it right away. Probably not. They'll need time to brief the case, and so that may delay the beginning of the case.
So can you talk to us while that motions are going on, why would the prosecutor wait on having the beginning process of the jury selection being decided on?
That's a great question. And for folks that are just watching this, the prosecutors asked to wait to, in what we call panel the jury, to select the jurors. And what they said is, we don't know all the charges that are going to be laid against Derek Chauvin. And so we do not want to give him the opportunity to appeal this decision. So it might be a little confusing. Well, why do they seem to be slow right now? Well, they would rather wait a few weeks and take away an opportunity to appeal, because what could happen is, and this is the argument that they made before the judge. They said, well, if we get a conviction and then he appeals, and they said, well, I never had the right to properly select a jury because we didn't actually know what the charges were going to be. Your Honor, we don't want to give him that opportunity to appeal this decision, so we'd rather wait. And the judge said, well, we don't think you need to wait. So they're going to begin to select jurors. They're going to begin to interview jurors. But that's why Attorney General Ellison and his team, why they were asking the judge for that, to wait on that.
So speaking about the charges, can you explain to us right now, outside of the third-degree murder that's still being pending?
Yes.
What are the charges that Chauvin is actually facing in this trial? Could face.
As I understand it, there are 2 and now soon to be added 3 charges. And right now we're at the space where the appellate court, the Court of Appeals, has instructed the lower court to add that murder in the third-degree charge, but that actually hasn't happened yet. And so we're waiting, but we expect that to happen as long as the Supreme Court does not tell him to do otherwise. So the first charge is manslaughter, which was that this was an accident. The second charge is not. So there's murder in the.
To me, it was an accident. But keep going.
No, this is the charge. This is one of the things
Right.
that the jury could conclude. The second is that this murder took place during the commission of a felony. And so you have to prove both that there was a felony, and you have to prove that the death was the result of that felonious behavior, and not the result of any drugs that may have been in George Floyd's system, or any other cause. That it was the result of the conduct of Derek Chauvin. So that's murder 2. There is a third charge, which is murder in the third degree, which is when you show a callous indifference to human life. The statute calls it a depraved mind. And you were so indifferent, you were so depraved in your indifference towards human life that caused the death.
And this was the charge that Mahmoud Noor
yes.
Was eventually charged.
Yes, that's correct. And so the district court judge said that Mahmoud Noor still has the opportunity to appeal that decision for another few days, and so that's why he's not bound by that court's decision. But the appeal court, the Court of Appeals, said no, actually you are bound, and so you should add that same charge, and so Derek Chauvin should also have that charge pressed against him, and he has to defend that charge as well. And why that's important for the prosecution is that the prosecution, they're going to make the best case that they can, but then they don't get to talk to the jury. The jury talks amongst themselves and comes to a decision. And if you want to give that jury as many chances as you possibly can to get a conviction. And if you have three, that also opens up the possibility, if you have different groups that have different thoughts, as they internally build consensus, because the judge is not in that room, the prosecutors are not in that room, those are people talking amongst themselves. It gives that jury another opportunity to reach a consensus where they all could conclude what happened there was the result of a depraved mind that was callously indifferent to human life. And that's an opportunity that Attorney General Ellison has asked the appellate court for, and that they have directed the trial judge to say that's important, that the jury have an opportunity to consider whether that was what happened.
That's a lot. And so jury selection, oral arguments for people who saw Law and Order or SUV, or what is that timeline looks like for the rest of the case?
Well, that's a really good question. At this point, we don't know. We did find out that there are potentially hundreds of witnesses. I want to say 350 or 360 potential witnesses for the state who could testify. Now, all those people won't testify, but a little bit, this is like a game of chess, and you don't necessarily know how long that chess game is going to last. If you have an excellent witness who can establish the facts that you need to establish, and you evaluate the jury, you have to make those decisions as a prosecutor or as a defense attorney.
Right.
Have I made my case? And if you think you've made your case, you don't need to
Keep bringing.
you don't need to, and in fact you don't necessarily want to bring 10 more people, because if you feel like the jury is with you, why would you bring in somebody that could compromise that position? And so when the state believes they've made their case, they will tell the court, "We've made our case, Your Honor. We rest." That's what they'll tell the judges. We rest, Your Honor. And at that point, the energy of the case goes from the state proving their case to the defense trying to take that case apart, trying to put the facts that have been established in a different context, in a different light. And all throughout that process, every time the defense brings a witness, the prosecutors will have an opportunity to poke holes in that witness's testimony. That's called cross-examination. And so there are rules that limit how a lawyer can talk to a friendly witness, but there are less rules for the cross-examination. So you can be much more aggressive and much more direct in the cross-examination, because you're really trying to find where the inconsistencies are, where the errors in what they've said, or if there's even a lie. You certainly want to expose that.
So that process goes on, and then eventually the jury comes to a point where they have to take the case and go into that room and
Yes.
without the judge, and come back with a verdict.
Yes.
What happens if one of the juries is not? They don't agree.
Well, the judge will be unhappy.
Right. We won't be happy either.
Everybody will be unhappy, but it's unlikely that the judge will be satisfied with that outcome. And so you asked the question, so what happens if one juror is different? Say one juror does not want to convict. Well, our system of justice requires that everybody agrees.
Right.
And so in the event that there was one or two jurors that couldn't agree with the group, we call that a hung jury. The judge is if the jury says we can't decide, it is exceedingly likely, it's nearly certain, that the judge will say, you need to go back
And get this
and
right.
you need to spend some more time with that evidence, and you need to talk with your fellow jurors, and you need to come to a consensus. And so the judge could even do that 3 or 4 times, because the judge has, and I mean, in this case, it's not hyperbole to say the whole world
Right.
is looking for justice.
The whole
in
world
this,
is watching this case.
Yeah, but
and
that is ultimately our system of justice is not the judge deciding. in this circumstance. It's the jury deciding. So in that case where the jury is unable to reach a verdict, then it will be a mistrial, and it will be up to the state to begin this process all the way from the beginning. And the beginning begins with a charging document to say we are going to charge this person. Then there's something called an arraignment or a first appearance where they're going to come before the court and they're going to present
Start the whole
so
process
you
over.
so you're not just it's not just a retrial. We call it a mistrial, and they'll retry them, but it's beginning from the very beginning of the charging process.
This trial for a lot of people brings a great deal of emotion, and it's going to be a watched trial. Every interview, every witness, every motion,
Which is the first time in Minnesota history, by the way, that's
Yeah.
happening.
right. There's a lot of firsts.
Yes.
There's a lot of firsts, and but I think for the community and everyone who's watching, I think it's important that we realize that we demand justice, that we also examine the system that's in place and how the court proceedings and how the court process, because there's a lot of opportunities as a community to see a lot of opportunities to change how the system is set up, how the system is. So we shouldn't just be following the case for the purpose of the killing of George Floyd, but really what's
Yes.
been happening for decades in these systems. And as many cases similar to this. Well, first of all, there's not many cases similar to this, but in the light that a lot of people may have never experienced this courtroom, and there's a generation of people that don't remember the O.J. Simpson trial, some of these more famous
Yes.
trials. So personally, I think it's exceptionally important that we pay attention, because there's a lot of opportunities for change. You talk about naming the defendants, or talking about individuals who are impacted. This is the Chauvin trial, not the George Floyd trial. George Floyd's not on trial. Chauvin's on trial.
That's right.
So with that, Simon, thank you so much. I think this has been very helpful.
Thank you, friend.
A good little explanation. I know a lot of people want to know some basic information around what the trial means, where we're at right now, and we look forward to having you back to kind of give us a little bit of an update as this trial moves forward, and we provide you more information so that you're also aware. We need to continue to understand the system, to hopefully fix this system and deal with it, but also, and most importantly, to recognize what's happening right now, and to see the clarity between all of the information that usually comes on our 24 hours news cycle.
Well, thank you, Jelani, and thank you to you and CARE and all the advocacy that you guys continue to do. And I appreciate so much what you're saying about the policies that need to change too.
Mm-hmm.
And I think it's really important to remember that at the end of the day, whatever happens with the outcome of this trial, we still have the same work to do. All the policy, if we get a conviction or we don't get a conviction, the policy work still has to be done. And it has to be done in the city councils and the state legislatures and in the White House. And so I thank you for the work
Absolutely.
that you do. And yeah,
Absolutely, and we know we're working on with a large coalition, the Minnesota Coalition, mncoalition.org. You can visit, and right now we have bills going through the state capitol. So while we protest and march and demand for justice, it's not just demanding justice for George Floyd, but really to fix the system. And so I encourage everyone.
if people want to do that, how should they get involved? How can they connect?
Well, you can go to mncoalition.org, and you will see the bills. And as an individual, you can sign up and be part of the movement. As an organization, if it's your church group, if it's your whatever group you're part of, you can join as a group and take part. Minnesotans, we are all at the forefront of leading our effort for justice. And I think George Floyd and all the families, because many families have never got this, and their cases never got interviewed. They didn't get filmed. And in Minnesota, we have a track record of 400 plus people since I think 2000 that have been killed by police in one form or the other. So we've got a lot of families that are hoping that this trial can be an opening for them and their families, that one day that they can also get justice. And I think it's important for people to realize that we as Minnesotans can do that. So we've got a lot of work ahead of us, one day at a time, but we're going to fight and continue to do that.
That's one thing I was going to mention, that somebody had a really great question, which was, why did Keith Ellison appeal to have third-degree murder added to the case when we already had second-degree murder? Was he actually lowering the charges? And he was not lowering the charges, but he was adding a third charge, which is a third opportunity to get a conviction. That was a good question, and I just want to make sure we talked about that.
Good, good.
Thanks.